Today we're going to talk about when it's a good idea to file California amended returns, especially after an FTB audit. The goal here is to avoid double exposure and missing protest rights. Some taxpayers have come to believe that after an FTB audit, a potential solution to disagree with the audit is to just file an amended California return and then move on. Listen, this is absolutely the wrong move. In many cases, the wrong amended return can waive protest rights, create inconsistent positions, and spread the problem into additional tax years. Hi, I'm David W. Klasing. I'm a dual licensed tax attorney and CPA, and I'm the owner of the tax law offices of David W. Klasing, to date 24 offices in 11 states, 12 across California. Today we'll explain when a protest makes sense and how to avoid turning one audit into multiple problems. So what happens after an FTB audit? After a Franchise Tax Board audit, the Franchise Tax Board, they may issue a Notice of Proposed Assessment, an NPA. If you disagree, you generally have 60 days to file a formal protest. If you miss that deadline, that assessment becomes final. That is why filing an amended return is inappropriate and does not replace the need to preserve those protest rights. So what does an amended California return actually do? Well, amending a return in California can serve many different purposes. It can be used to correct a return. It can be used to claim a refund, to report federal changes following an audit or some sort of adjustment, or to adjust prior calculations. But it's rarely the correct response to an active auditor inquiry or pending notice of proposed assessment. There's a risk of double exposure here. A careless amended California return could create a second front in the tax controversy. It introduces new computations, new factual explanations, new documents, and new legal theories. Instead of resolving the audit, it can complicate it further. That is why post-audit amended returns must be handled strategically, if ever. First of all, the amended return in California does not reset the statute of limitations. An amended California return does not erase the audit posture or restart deadlines with the original audit. It simply adds another filing to the existing record. This can lead to multi-year consequences. California audit adjustments often affect carryovers, credits, and sourcing issues. That means that one amended California return can impact multiple subsequent tax years. Without careful planning, a correction intended to reduce one liability may create additional exposure elsewhere. So, what does a good California amended return look like? The best amended California returns are narrow, well-documented, and internally consistent. The amended return is going to explain exactly what changed, why it changed, and which documents support the change. The goal is to correct the issue with the original return, not rewrite the entire narrative. So in closing, if you're considering an amended California return, you should first determine whether a protest, a tax deposit, a refund claim, or amended return is the right procedural path. At the tax law offices of David W. Klasing, our dual licensed tax attorneys and CPAs help taxpayers coordinate California and federal positions while minimizing additional exposure. Call 1-800-681-1295 or visit klasing-associates.com to schedule a confidential, reduced rate initial consultation today.